Welcome to Frank Bruno Law. I am Frank Bruno. I'm an elder law and probate attorney in New York. Today I'd like to tell you a little bit about signing a will, executing a will in the age of COVID, and whether or not a will made in another state would still be valid. Before I get to that, if you would like to speak with me, if you have any questions for me, please send me an email, frank@frankbrunolaw. So today, I did a drive-by will signing. I drove to a client's home. She came out of her home, and we executed the will on the sidewalk. I brought along two witnesses, two young, healthy 18-year-olds. I had a mask and gloves. Both of my witnesses had masks and gloves, and so did the testator. That's the person that's going to sign a will. And the interaction with this client had taken place all online. I had spoken with her on the phone, gave her a will intake form. We went back and forth in email. We had several phone calls. We made modifications. Gave legal advice over the phone. Legal fee payment was made over the phone. And today was the first time that I met with her. And what we did was the two witnesses drove in one car. They had been in contact with each other, and that wasn't an issue. And I drove in my own car, and I brought a folding chair and a card table. So just set it up on the street, and the will was read by the testator. It was the same will that had been sent by email, and the back and forth exchange. And then we took all of the formalities of a will signing and just did it there. The will was declared to be the last will. The witnesses observed. We all signed in the presence of each other from a slight distance until we got close to the card table. And it actually went quite well. I should have taken a picture for the Instagram, but I figured it was okay not to. The person that signed the will asked me a question. She had a will from another state that she had not ripped up or revoked prior to today. And the question was, a question about that, whether or not she needed to do anything. And the best practice is to take the past will and rip it up. The new current will, the legally enforceable valid will executed today, will take the place. However, if the old will and the new will are both in existence, and if they have different material terms, it could cause potentially a will contest, right? A person that was dissatisfied, happy with the first will and dissatisfied with the second will say that second will shouldn't be valid for a reason. And they'd have to advance a reason, but that's potentially at risk if you have two wills that could be, both looked at the same time. The later in time will, if both were legally executed, properly, all of the formalities of a will properly done, the will second in time will take precedence. But who needs that other will floating around? Just rip it up. All right. Thank you for your time. If you have any questions, if you'd like to speak with me, please send an email, frank@frankbrunolaw. Thank you.